Hi everyone, my name is Alec Davis, founder of MediatorAcademy.com, home of the passionate mediator. You know what we do on here? We interview the very best mediators and thought leaders from right around the world. This is the place for us to learn about new opportunities in our field, as well as how to overcome some of the challenges, dilemmas that life as a mediator presents us. Ultimately, the goal here is to learn, grow and improve our effectiveness. Now, my guest today is Chair of Canada's first ever online tribunal and grounds her leadership of the Civil Resolution Tribunal in her long-standing commitment to access to justice, particularly in the context of administrative tribunals. An active provider of pro bono legal advice and representation through her career, she's also adjunct professor of administrative law at the UBC Faculty of Law, a commissioner of the Financial Institutions Commission, and vice president of the British Columbia Council of Administrative Tribunals. Whew! She has also served as vice chair of the Workers' Compensation Appeal Tribunal, a litigation lawyer at a large Vancouver law firm, a board member of the College of Registered Nurses of British Columbia, and a judicial law clerk with the British Columbia Supreme Court. I think I've got everything in there. There's probably a lot more I've missed out. But hey, it's a real pleasure to welcome Shannon Salter onto Mediator Academy. Shannon, welcome.
Thank you for having me, Alec.
Now, I interviewed Darren very recently about the Civil Resolution Tribunal and the big project that you guys are doing, and he said, you must interview Shannon. So here you are. I want to find out a bit more about the initiative that you guys have been working on over in British Columbia. I'm interested in learning about, some of the challenges you've encountered in getting it off the ground, how you currently resource it, what the implications are for mediators, what advice you'd give for somebody trying to do something similar over here in England and Wales, all these sorts of things. But let's start right at the beginning. So for anyone who hasn't watched Darren Thompson's interview, also known as the international justice celebrity, tell us a little bit... He
loves that, by the way.
He loves that, right? Tell us a little bit more about the Online Tribunal.
So the Civil Resolution Tribunal, as you mentioned, will be Canada's first online tribunal, and it will have jurisdiction over what's called small claims matters in British Columbia. So these are civil disputes about $25,000 or less, Canadian dollars. Mm-hmm. Things like debt or contract, personal injury, specific performance. But the monetary value of those claims is low, and the number of them is pretty high. So there's 22,000 claims like this in BC currently. So the Civil Resolution Tribunal will have jurisdiction over those claims, as well as what we call strata or condominium property claims, which I understand are roughly equivalent to shares in freehold or shares in leasehold disputes in your world. So condominium disputes are disputes between owners who all live in the same building and share ownership over the underlying land title. And in BC, in British Columbia, there are 1 million people who live in strata or condominium type units. And that number is increasing because older people, the baby boomers, are downsizing, selling their homes, and moving into flats in these condominium units.
Right.
So it's an area that's growing really rapidly, not just in British Columbia, but across the country. But right now, owners who have disputes within these settings have to go to the court to resolve them, and it can be very expensive and time-consuming. And so as a result, it's really not a viable option for most people. So the Civil Resolution Tribunal is going to give those people a forum in which to resolve their disputes very quickly, very conveniently, very inexpensively, ideally from their tablet, their mobile phone, their computer, in their home or in a coffee shop, wherever they happen to be. And so the technology is one tool, but the other piece of the puzzle that's just as important or maybe more important is giving people different tools. So not just having an adjudicative decision at the end. Mm-hmm. We offer that too, if that's necessary. Yeah. But first, front-loading the process so that we're putting a lot of effort into early resolution through facilitation, people with mediation skills, negotiation, those kinds of tools.
Okay. And so I've got a dispute with someone that lives above me in my condominium, and I'm looking for a way of resolving that dispute. How would I actually find out about this if I was, a member of the public?
We have set up a website to give people information as we implement the tribunal. So the tribunal's not up and running yet. We're hoping it will be up and running later this year. But we do have a website to explain to the public how this will work. It's at civilresolutionbc.ca.
Okay.
And so it's voluntary for people for the most part. There's some exceptions. It's voluntary. People can use the existing court structure or they can use the CRT. But beyond the website, we're trying really hard to get the word out through advocacy groups, through the court registries where people would go to file their complaint, to know that there is a different way to go about doing that. Yeah. But building public awareness is really important, and it's a new thing, so it's not intuitive for people to use yet.
Yeah. So let's say later in the year the website's launched, I could go online, search for how do I resolve this issue with my neighbour. Your website would come up in the search. I could go on it, and what next?
Yeah, so the front end of the Civil Resolution Tribunal is something that Darren is really heading up, which is what we're calling the Solution Explorer, and it's a series of guided pathways, which is really like an intelligent questionnaire. Yeah. So people would pick the area of their dispute, they would answer some questions about the nature of their dispute, and along the way they'd be given really targeted pieces of legal information and tools to resolve the dispute on their own, to take a crack at it themselves. So we know from research now that it's not useful just to scan a bunch of PDFs and throw it up on a website and say you're providing legal information. It's you're setting people adrift in an ocean by doing that. Yeah. Instead, what people need is to be spoon-fed little bits of information that are directly relevant to their dispute. And that's what Guided Pathways lets you do, because you can find out exactly what their trouble is, what the trouble spot is, and then link that with resources like template letters that they can send to the opposing party, for instance. Tools about how to manage high conflict situations. And at the end of that process, they can either go off and use those tools to try and resolve the dispute themselves, or they can click a button and enter into the Civil Resolution Tribunal process. And then they're carried along that process. And that process isn't one size fits all. It's there's a negotiation phase initially, then a facilitation phase, which I think is really the heart of the tribunal. That's where I think the magic will happen, hopefully, through skilled mediators who we're calling facilitators. And then there's adjudication as a last resort. So the adjudication process is where an adjudicator or tribunal member makes a binding decision, and that's enforceable as a court order. So people do have certainty that at the end of the process, they will have a final decision. They're not, one way or the other, their dispute will be resolved, but we're giving people every opportunity along the way to help craft their own solution, to be empowered with choices about how it's resolved. And then if that fails, though, adjudication as a last resort.
I think it's a brilliant idea. Just a question, actually. What was the thinking behind using the term facilitators and not mediators? Was there? I'm guessing
you picked up on that, but that was a conscious decision. And you would know this better than I would, but mediators, especially in Canada, can sometimes think of mediation as meaning something very specific, interspace mediation that has a particular process to it. But the Civil Resolution Tribunal Act and the way we're designing the process is much more flexible than that, is much broader than that.
Right.
So I think if we called what we envision this dispute resolution process to be, if we call that mediation, I think it might annoy some mediators who say, well, that's not mediation. Really, that's something broader and looser, and it's not really what I consider mediation. So, we're respectful of that. But at the same time, we're envisioning a process that is that's fluid, that's flexible, where we're giving people who have dispute resolution abilities a wide variety of tools to help craft consensual agreements between the parties.
Yeah, okay. So you talked about the volume of small claims cases currently in the courts. You talked about sort of the condominium number of tenants you've got, and that rising, and one would anticipate, the number of disputes rising in conjunction with that. What are the problems that you're trying to solve more broadly through this innovative initiative?
Well, and I think, and this isn't unique to Canada or British Columbia, but there's an access to justice crisis, not just in Canada, but really likely in a number of Western countries. And in Canada, what that looks like, more particularly in British Columbia, it means that there are significant delays to getting into court, even at a small claims level. Mm-hmm. It can be months, if not years sometimes, depending on where you live in the province, to get into court. British Columbia has a concentrated population in a few cities, and then a number of rural communities. It's a huge space. Okay. And and many of the people who live in rural British Columbia and rural Canada generally don't live anywhere near a courthouse. And so for them to resolve their dispute within a court process, they often have to travel hundreds of kilometers to get to a courthouse. They incur travel costs. They have to take time off work. They have to arrange childcare. It's expensive, time-consuming, and very inconvenient. And at the end of that, both at the small claims court and at the superior level courts, the number of cases that actually end up in a trial is very, very slim. Mm. So in the BC Supreme Court, that number's around 2 to 3%. It's a little bit higher in the small claims court, but the entire system is oriented towards that day in court. Yeah. That in the vast majority of cases just never comes. Yeah. And so I think as a legal community, we have what's sort of known in the social science as the myth of settlement. That, well, if 97 or 98% of these cases just go away, they must just settle on the courtroom steps. The system works. But we know that that's not true. Yeah. We know that people run out of money, they get tired, evidence goes away, they get fed up. It takes a toll on people's well-being. Mm. And the underlying disputes, though, don't necessarily go away. So what we're doing is fundamentally different, because we're flipping that process on its head. Instead of putting all the resources on the back end, driving towards this event that we know almost never happens, yeah. We're flipping it around, so we're putting all the resources on the front end. Get people in and out of the process early. Yeah. Give them ownership over the process. Yeah. Empower them with choices. Instead of making people go to where the justice system is, even if it's nowhere near where they happen to live, and even if they can get there, it's often very confusing and complicated, and literally the language is not one that most people speak. Yeah. Instead, we have a real chance here to build the justice system around where people are. Yeah. We go to them. We go to their living rooms. We go to their computers. We give them the choices about how they want to do it, and we do it in how they want to resolve their disputes, and we do it in a really plain language, easy to understand way, because it doesn't need to be that complicated.
So justice isn't this wood-panelled room that people turn up in. It's a service. It's a user-centric service.
Yeah, and I think it goes beyond that. I mean, we are used to engaging with services through technology, our banking, bill payment, even paying our taxes. Yeah. But I think justice, we're certainly offering dispute resolution services, but I think it's more foundational to that. And this is where I get a little loftier, I think, than Darren. He's a very pragmatic person, which has been phenomenal. But to me, I see this as something more foundational, that if you don't give people an accessible way to resolve their disputes, you undermine civil society. You tear out the cloth of civil society. And you promote vigilantism, you promote people's disenfranchisement from democracy and society generally. And when you have 1 million people now living in very close quarters with the natural kind of community disputes that come up in that environment, and don't give them a viable way to resolve their disputes in a civil, respectful way, then you're undermining your society. Yeah. So even though these disputes are small, I think that they're small in terms of dollar value, they have a huge impact on people's lives. Mm-hmm. And on an aggregate level, it's foundational to society that people are given a reasonable way to resolve them.
I can see you're really passionate about this.
Yeah, sorry. It's true. I hope I could get off on a rant there.
No, well, it's I think it's really important what you're talking about. It's so important to, the sort of the philosophical underpinning really of why you're doing what you're doing. Have you always been this driven, this motivated about improving access to justice? Is it something that you woke up one day and decided? I mean, where does it come from?
I think for many of us, law school really brought that to bear. You have opportunities to volunteer in law school, to help people who need legal assistance. And, doing that opens a door on a whole world of people for whom the existing system is just not accessible. It's just not a possibility. And I think, we know that in theory in a lot of ways, but when you're sitting in a legal advice clinic and people are coming in with their real problems, and they can't even navigate the first steps, you realize it's not working for them. It's failing them. Yeah. And so for me, that had a very powerful impact. I know it did for a lot of my classmates as well. And it's something that's really informed what I've wanted to do since. So even when I was in private practice, it was a big part of what I was doing. And I've tried to keep that thread along my career. But then seeing this opportunity, I think it's an incredible opportunity to just rebuild this little corner of the justice system, to go to where people are. This is, if you have a civil problem, and it's not a family law problem, it's likely to be a small claims problem. This is where people have an entry point into the justice system. And if we can change this part and it works, then maybe there's implications for what we can do in other parts of the justice system as well.
Yeah, I wanted to come on to that. I mean, it's really interesting how you describing your experiences volunteering as a student and so on, working on the ground at the coalface, where the difference that you can make to one person's life or their family, or you get almost an immediate bit of feedback really. Your role now, you have a real opportunity to leverage change, right?
Yeah, I think we do have a real opportunity, and it's going to be a question of whether we can really seize that, whether we can just whether we can roll it out and launch it in a way that inspires public confidence, and really demonstrates to them that we're committed to improving it. Yeah. So I think it's really important to note that this is it's an experiment. It's innovative, yes, but it's an experiment, and that means it's not going to work perfectly out of the box. It's going to have glitches, and when I'm talking to different groups and engaging with different communities, we talk about that. That I'm depending on them to come back and tell us what's not working and how to make it better. Yeah. And I'm also committed to going back and asking for that feedback many times along the way, not just in the implementation phase, but in the years after the tribunal operates as well. And really, it may sound naive, but what I'm hoping to foster is this collective responsibility for this project, that we're all invested in it. We all want it to succeed, but that means that it's going to be about improving it together, about continually improving it together. And the technology lets us do that. It lets us be agile with improvements. Yeah. We're not going to be waiting sort of 2 or 3 years down the road for a study about what's working or what's not working. If someone tells us, well, there's a dead link here, or you've forgotten this stream, that's something we can build out right away the next day. Yeah. No, or the next week.
I mean, technology is incredible. I was playing around with a program today. It's called Optimizely. And Optimizely is a SaaS product, software as a service, that enables you to A/B test certain aspects of your website. Do you understand the content? Yeah. So you can literally change. So I played around with changing the text on a button that says "Join now" or "Get started," and but so I did that this morning. By the end of the day, I can make a decision based on data as to which one gets more clicks, and so that you can make changes that are data driven, are influenced not by one's inference or feeling, and I think that's important, building something that people need and want and will use rather than what you think is good for them.
No, that's right. And I think it's especially important to have that humility in an access to justice project. So, we're going out and meeting with all kinds of groups that are not telling us what we would love to hear, that everything's going to be just fine and their clients won't have any trouble. We're seeking out people who might have barriers to using the CRT, people who might have mental health barriers, language barriers, accessibility barriers, and we're actively working with them to identify where those difficulties might lie and how we can address them. And I think you have to do that. If you have an access to justice project and you're saying it's an access to justice project, then it better account for people who have barriers. And so I think this is going to work fantastically for the 80 to 90% of people who are reasonably computer literate, in the sense that they can use a smartphone, maybe pay their bills online, use email. But we also have to concern ourselves with people who may not be as comfortable with the technology or might have these barriers. And there's lots actually that we can do to make it a more comfortable place for them. But it requires sort of removing your ego a little bit and saying, I'm not assuming that I know what's best for you. I need to ask you what's going to work and what's not going to work, and I need to keep checking back. So I think that's really, really key, is not going on just what you think is best. It's not a father knows best approach to justice reform. It has to be from the ground up. You have to be working with the people who will actually use the resource.
It's a lovely website. It's very clean. It actually looks more like somebody's blog. It doesn't look like an official government. It's a lovely looking thing. I noticed on there there was a post where you are recruiting for tribunal members. Is that right?
Yes. Yeah, so in British Columbia, it's the government that appoints the tribunal members in consultation with the chair, for the most part, of a tribunal. And so the government is recruiting part-time members, and in fact, the deadline closes today for that.
Okay.
But yeah, that's one exciting milestone that we're moving forward with. We're getting some of these tribunal members who will be in place, even though there won't be any decisions for them to make for a few months yet. Is part of having the human infrastructure behind the technology ready and in place, so that when the time comes, it can all launch. But what you were saying about the website, that was intentional. We and I think that's also part of trying to remove the ego. As lawyers, I think we get very attached to the way that we talk, and we think that the way we talk conveys our intellect, our education, our knowledge. But it can get in the way of actually communicating properly with members of the public who don't have that legal background. So we really tried to make this implementation website as inviting as possible, as plain language. It's written at a very entry level language level. And that I found personally was quite a humbling exercise, because I would write content that I thought was really plain language. And then I would send it to my colleague in Victoria, Lisa, who actually knows how to write in a plain language manner, and she would rewrite it and send it back to me, and I'd say, wow, that's actually properly what somebody without knowledge in this area would need to read to understand it. So it did show how hard it is to get outside of your own framework, but we need to do that, and we maybe need to hire experts to do that, to write things in plain language. But that's, again, not taking a paternalistic approach to justice reform. Instead, you go to where people are and you communicate in a way that's easy for them to understand.
Is it a libertarian paternalism?
Is it a libertarian? What do you mean by that?
Have you come across the concept of nudge?
I haven't.
Okay,
no.
It's a great book. I recommend it. Nudge. It's about libertarian paternalism. So you try and help people make better choices by putting. It's a bit like if you've got a queue of children or adults at a cafeteria, and you put all the fruit and salad at eye level and all the chocolate and cream cakes just out of eye level, so they can still access the chocolate and cream cakes, but you are nudging them to make a better choice by presenting the more healthy options.
I see.
And it's quite it's quite an interesting sort of phenomena, really. But by presenting something where people can make free and informed, it's a voluntary thing, right, to participate in this, so they can make free and informed choices. But you want to make it as appealing and as easy for them to use, just to encourage them and invite them to use it.
Well, I would not like to characterize us as libertarian or paternalistic. Oh, it sounds sort of like Santa Claus meets Ayn Rand or something. And as fascinating as that is, I think what we're trying to do is democratize this process, to remove barriers that act as gatekeepers for people to access this. And the way you do that is you make it less intimidating. And the legal system is very intimidating for people. It can be intimidating for lawyers, never mind somebody who doesn't have the experience or the resources to access it. So when you remove the language barrier, you certainly remove all Latin, but you remove other complicated ways of explaining things. Yeah. Then you make it more accessible. Yeah. And it's not that a lot of these concepts are so complicated. Yeah. There's no reason they can't be explained in terms that people really understand. Yeah. But if we're trying to make an alternative, it really does need to look quite different from the existing path, right? Yeah. It needs to speak to people, and I would like people to be able to visit that website and say, I understand what this means, and I think I can do this. Yeah. Not to shy away because they're so scared of making a mistake or being embarrassed, or it just seems too daunting. Yeah. So I see that as our role. Yeah. And this is just the implementation side, and it is meant to be sort of an informal blog type thing. But the actual CRT site, when we're up and running, needs to have the same feel. It needs to instill confidence in people, to empower them, to make them say, this is my dispute, and I'm going to be able to resolve it on my terms. When I'm done work, when the kids are in bed, when I have a moment to think, and I'm going to be able to take a break if I need to go get more information or some help, and I'm going to be able to propose my own solutions along the way. So every chance you have to take ownership of it and to participate in your justice system, that's what we're trying to give people. Yeah.
It just sounds. I can't wait for when you thinking it's going to launch. I can't wait to see it.
All of us can't wait to see it either. Our best guess is summer at the earliest, possibly later in the year.
Okay. I don't want to put you on the spot. Yeah.
No, and I wish I had a more specific answer. We're all working day in and day out. I mean, I'm sure. The whole team in Victoria. You've talked to Darren, and everybody's so passionate about this and so committed and working so hard. A lot will depend on the technology and when the technology is ready. And then there will be a period of making sure that, we're not throwing the door wide open and just saying, come all, and use the CRT. We're going to make sure that it works in a staged, careful way, because we do want to ensure that we have the public's trust and that it's a credible way to resolve disputes.
Yeah. I saw some. I think I saw a presentation that you delivered. Some slides of a presentation you delivered, and you had some wireframes, some sketches of what the different levels looked like. Right. They looked really good, actually. Really sort of simple, easy to digest, plain, clean. Yeah, it looks good.
Thanks for the feedback. Yeah, we're those are sort of conceptual designs, but we are aiming for it to be like that, to be responsive, easy to use, very plain language. So it's that's our aim. I'm glad that's coming across.
So you talked earlier about sort of resourcing it and getting tribunal members in. I'm curious, what does it mean for mediators and ADR professionals? What are the implications, and how many facilitators, how many facilitators, do you imagine getting started with, and as it gets full to capacity, how will you operate? Any thoughts on that?
Yeah, so the facilitator role is an interesting role because the person's also a case manager.
Okay.
So they'll have to manage a reasonably high volume of cases, but also have really excellent dispute resolution skills. So it'll take a particular skill set and a particular person to do that work. But there is a real opportunity for mediators to do that work because they have those dispute resolution skills already, and that's obviously going to be valuable. We're trying to be as flexible as possible with our workforce. So largely our workforce will work remotely. Mm-hmm. Right now I'm in the CRT headquarters, which also happens to be my home office. We're a very efficient tribunal so far with government resources. But similarly, we want to draw on people who may be semi-retired, who might be stay-at-home parents, yep. who might have other work that they do and want to do a little bit of this as well. So we're really flexible about having part-time, full-time, even possibly some contracted services in this area. And in BC, there are courses now that are being designed for mediators to develop ODR skills. Mm-hmm. And the uptake on that has been really extensive. But so I think there is an opportunity here, but it will require a flexible view of what mediation means. Yeah. And the Act is really broad. It lets facilitators undertake what's really properly characterized probably as a med-arb model, mm-hmm. With the consent of the parties. So with the consent of the parties, the facilitator can make a recommendation or take an evaluative approach to a dispute. Even with the consent of the parties, the facilitator could decide the dispute. Yeah. So all of those things are sometimes controversial in the mediation community. Yeah. But if that's something that a mediator is comfortable doing, then this might be a good job opportunity for them. Yeah. And it's certainly very, very flexible. Yeah. Now, in terms of the broader context of mediation, this approach, if it's successful, will likely be rolled out to other tribunals over the coming years. And in BC alone, there's 27 to 29 of those tribunals. So on one hand, I think it will really increase the amount of work for people with dispute resolution skills because that will be embedded in the process in a way that it's not right now. Mm. On the other hand, it will require a much higher degree of flexibility in terms of what approaches people take to dispute resolution.
Yeah, I mean, it is interesting how, as I mean, there's a big tension in mediation between sort of the evaluative and facilitative and everything else in between, as to what's the right way to do it. And again, my mind has changed over the years that I've been practicing as a mediator. I'm a lot more open-minded these days, and the reason why I'm more open-minded is, I think we can get a little bit. Just trying to think of a polite way of putting it. We can get our heads stuck up certain places where, and ultimately if we put the responsibility or the accountability for the decision making down to the parties, we empower those to say, well, here are the options. You can come up with the outcome. I could make some recommendations. I could even decide it for you. What would you like to do? Rather than decide ourselves as a profession or a field what we think is good for people, let people make their own minds up what they think is good for them. Just give them the information, help them make their own mind up.
Yeah, and I think there may be some parallels there between the mediation community writ large and parts of the justice system and the traditional legal community, and that what we were talking about before in terms of paternalism, we need to be careful that we're not importing that into the mediation field, right? That we're not telling people what they want or what's best for them, barring things like duress or undue influence or where there's a clear imbalance of power. If you're talking about competent adults who are able to make decisions for themselves, if they're properly informed of all of the alternatives, really is it the role of the mediator to say, well, I know you just want an outcome right now or a decision, but I'm going to lead us down this process that's going to maybe cost you more money and take you more time. And I know that there are arguments on both sides of that, so I'm not meaning to presuppose one outcome or another, but I think it is something to be mindful of in any profession. Yeah. Are you serving people's best interests, or are we serving an ideology that may not be serving those best interests anymore? Absolutely. Need to watch for that. And I say that as a lawyer because I think the legal community in particular needs to watch for that.
Yeah.
We have our own sacred cows, and some of those deserve closer examination.
Yeah, no, absolutely. That's a topic for another discussion. Look, I'm mindful of time, and you've been really generous so far. I've just got to, just want to know really, what advice you'd give someone in England and Wales thinking of setting up something similar for disputes of small claims nature or particular disputes. You know, if we wanted to come up with an ODR platform that could provide that access to justice, that could really help people, empower them to make choices, remove that sort of difficulty, all the barriers and all the pressures, but also all the sort of sense of intimidation. What advice would you offer?
I think it's a tricky balance between having to lead change, and especially the role is for government, I think, in this area to lead justice reform, but also make sure that you're not leaving people too far behind. So the change management part of it, I think, is so important. It's so key because you want to develop a collective sense of what the problem is and why you're trying to address it, and then you can move into the solution, whatever form that may take. But definitely talking to different people, talking to groups who are currently marginalized by the justice system, talking to legal actors, but not only talking to legal actors. I think often when we talk about justice reform, we maybe consult lawyers, we consult judges, and that's really important. But we forget sometimes to consult people who have actually engaged with the system in the past, people who have specific barriers to engaging in that system. And if we're trying to reform the justice system, you need to go to the people who are most impacted by it. And so that would be my suggestion, is try to strike that careful balance between bringing people along, holding them by the hand, reassuring them that you're not throwing out the baby with the bathwater, but trying to inspire them with a vision of how things could be. And I think particularly in the legal community, there can be a concern that if government is trying to change the process, that they're somehow trying to undermine the process.
Yeah.
And it's important to explain, I think, that no, especially in the CRT's example, principles like the rule of law or procedural fairness, those are so foundational to everything that we do. And that has been the sort of collective product of hundreds of years of the common law and our attachment to precedent. But our attachment to precedent as lawyers can become really unhealthy when it stops us from considering changes to process. So when I talk to groups of lawyers, I try and really get them to separate in their minds for a moment the principles that are so foundational to our justice system from the process that gives effect to them. And if we can be a little bit more open-minded about the process, and we can reassure people that we still care about the principles, then I think there's an opportunity to say, well, if we were to start from scratch now, how would we build these structures that give effect to these principles? Would it be in a brick and mortar building all the time? Or would it look a little bit different? And you have to work with the courts to do that. You have to work with lawyers, but it's really important to really go to the public and not be paternalistic and learn from their experience with the justice system. It's a rather long-winded answer, but it's a complicated problem.
Some very, very useful advice there. Look, Shannon, I really appreciate your time. I know you've got a busy day ahead of you. If people want to find out more about the CRT, what's the best way of doing that?
Log on to our website, civilresolutionbc.ca.
Okay.
And there's a way to contact me there too if you have any questions, and a way to get more information about the tribunal. And we have great guest posts from people like Darren. We have a guest post from a self-represented litigant, from mediators. So it's a good place just to get different views on this process from a number of quarters.
Wonderful. Listen, I wish you all the very best with the launch. Whenever I'll be keeping my eyes peeled for it. And thanks once again for doing the interview.
Thanks so much for having me. I really appreciate it.
Thanks, Shannon.